how ignoring written discovery can kill your personal injury case. Now, written discovery is just a formal way of saying written questions back and forth. One side of a lawsuit will send a bunch of written questions to the other side, and then the other side's probably going to do the same thing. So it sounds like no big deal, but it's really important because it helps both sides find the key evidence, understand the facts of the case, know who the witnesses are, know what the world of the documentary evidence is going to be. So even though it's annoying, intrusive, time-consuming, it's important, so it needs to get handled. So what if you ignore written discovery? Well, there's all kinds of consequences from that because the court knows that this is important. And so there can be various forms of sanctions all the way up and through dismissing a case. So in a particular instance, we will call her Sue. Sue had a lawyer in her case, and Sue was going on through litigation. And then for one reason or another, Sue never had a lawyer. Sue lost her lawyer. So what happened? Well, Sue was the plaintiff in the case bringing the lawsuit, and there were lawyers for the defense of the case. Well, now Sue didn't have a lawyer anymore. So what did the defense do? They sent written discovery to Sue. They sent her requests for admissions, they sent her interrogatories, they sent her requests for production of documents, and Sue is not a lawyer and she didn't know what to do. Well, what are the consequences of not participating? Well, the other side knew very well that if you do not respond to requests for admissions, here where I practice law in the state of Nevada, the court can go ahead and deem them admitted, which means the question will be determined to have been admitted. So very typical, one of the questions was, admit my client was not negligent. Well, if Sue doesn't respond timely and the other side brings a motion for the court before the court to say deem these admitted, well, suddenly Sue is now admitting that the defendant was not negligent. Well, if the defendant's not negligent, the case is gone. So don't ignore written discovery. If you have a lawyer, definitely talk to your lawyer about what objections need to be raised, what documents need to be produced, what things need to be admitted and not admitted. And if you don't have a lawyer and you do have a lot of questions about discovery, you may want to consult with a local lawyer in your jurisdiction that does this kind of thing. If you're in Nevada, please feel free to give me a call or drop me an email.